Welcome to the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar.
Hello, everyone, and welcome to another podcast hosted by the City Bar Presidential Task Force on Artificial Intelligence and Digital Technologies, which we will refer to as the Task Force. Today, I'm joined by three panelists who are members of the Task Force. Each of them will introduce themselves immediately before they discuss issues related to President Trump's December 11 executive order on ensuring a national policy framework for artificial intelligence, which I will refer to as the National Framework. My name is Jerome Walker, and I will moderate this podcast. By way of background, I'm co-chair of the task force. The National Framework itself suggests it is a continuation of President Trump's January 23rd, 2025 executive order titled Removing Barriers to American Leadership in Artificial Intelligence. At the outset, I will assert that many policymakers at the state and federal level have urged Congress to develop a national framework on AI, and I will further point out that I also believe the U.S. needs a national framework to assure responsible AI. But a national framework that assures responsible AI does not necessarily mean AI should only be regulated at the national level. The question many policymakers and other stakeholders will ask themselves about the national framework is whether the national framework should be established by an executive order and whether the approach taken by President Trump in the national framework is the correct approach. As with other executive orders on AI issued by President Trump, he's very clear on his intent. For instance, the national framework expressly provides, quote, United States AI companies must be free to innovate without cumbersome regulation, but excessive state regulation thwarts this imperative. First, state-by-state regulation, by definition, creates a patchwork of 50 different regulatory regimes that makes compliance more challenging, particularly for startups. Second, state laws are increasingly responsible for requiring entities to embed ideological bias within models. For example, a new Colorado law banning algorithmic discrimination may even force AI models to produce false results in order to avoid a different treatment or impact on protected groups. Third, state laws sometimes impermissibly regulate beyond state borders, impinging on interstate commerce. My administration must act with the Congress to ensure that there is a minimally burdensome national standard, not 50 discordant state ones. The resulting framework must forbid state laws that conflict with the policy set forth in this order. That framework should also ensure that children are protected, censorship is prevented, copyrights are respected, and communities are safeguarded. A carefully crafted national framework can ensure that the United States wins the AI race, as we must. Until a national standard exists, however, it is imperative that my administration takes action to check the most onerous and excessive laws emerging from the states that threaten to stymie innovation, close quote. Those quotes highlight the Trump administration's plan to limit the regulation of artificial intelligence in certain key areas. Today, we will focus our attention on the implications arising from the establishment of an AI litigation task force, the evaluation of state AI laws, the federal restrictions on state funding, the federal reporting and disclosure standard, the national framework's intent to preempt state laws it characterizes as mandating deceptive conduct in AI models, and the preparation of legislative recommendations to establish a uniform federal policy framework for AI that preempts state laws that conflict with the national framework. In preparation for this podcast, one of our panelists, Austin Brown, who is a co-chair of the Task Force Subcommittee on the International Regulation of Artificial Intelligence and an Assistant Attorney General in the Office of the New York State Attorney General, pointing out that on December 10, 2025, one day before President Trump issued the national framework, New York State Attorney General James and a bipartisan coalition of state attorneys general issued a letter urging a number of big tech companies to address dangerous AI chatbot features. We will also discuss the letter from the state AGs and how state AGs are likely to respond to the national framework. Another panelist, Stuart Levi, who is a co-chair of the Task Force Subcommittee on Artificial Intelligence in Commerce and Finance and a partner at Skadden Arps, pointed out that on December 19, 2025, New York Governor Hochul signed into law a modified version of the Responsible AI Safety and Education Act, or RAISE Act, which, among other things, requires transparency and reporting by frontier AI model developers for incidents of critical harm. It also creates a new oversight office within the New York State Department of Financial Services, and it provides enforcement authority to the New York State Attorney General's office. Our third panelist, David Lisson, who is a co-chair of the Task Force Subcommittee on Liabilities and Remedies related to the use of artificial intelligence and a partner at Davis Polk, will no doubt also point out that the RAISE Act was based upon the California Transparency and Frontier Artificial Intelligence Act. To help understand the national framework, its implications, and the likely responses to the national framework, I'm very pleased to introduce these task force members, each of whom has extensive knowledge and experience on a wide range of AI issues, including having worked with President Biden's executive order on AI and all of President Trump's executive orders on AI, including the national framework. These task force members are thought leaders and represent stakeholders across the spectrum. So let's get started. Austin, Stuart, and David, would you each please briefly introduce yourselves and your practice areas, and then I have questions for you. Please start with Austin, then Stuart, and then David.
Thanks, Jerome. I'm Austin Brown. I am a member of the New York City Bar Task Force. I practice in the New York Attorney General's Investor Protection Bureau. We are here to protect investors from various scams and issues that arise in the sale and purchase of securities. I am also working on a dissertation on the same subjects at the Sorbonne in Paris at the same time.
I think I'm up next. Stuart Levi, everybody. I am a partner in the IP and Technology Transactions Department at Skadden Arps in New York, where I focus on technology matters, including artificial intelligence. And I'm a member of the Task Force Subcommittee, as Jerome mentioned, on artificial intelligence in commerce and finance.
Hi, everybody. I'm David Lisson. I'm a partner in the Davis Polk IP litigation group. In addition to the sort of traditional IP litigation, I'm also head of our Gen AI litigation initiative, where we aim to help our clients get their arms around some of these regulatory issues, as well as manage kind of more general litigation risks related to AI use and development. And I'm a co-chair of the subcommittee that AI liabilities and remedies.
Excellent. So what I want to do now is get you guys to kind of drill down into the substance of President Trump's executive order. So I think we all will agree that to date, there's been very little traction in Congress to establish a national AI framework. So what I want is I want you guys to explain why Congress has not been successful, but by way of background, I want to just point out and to level set that you might recall that during the debate over the One Big Beautiful Bill Act, the administration sought to include a 10-year moratorium on state AI laws. But the Senate voted 99-1 to strike that moratorium language from the bill. So would each of you please explain to the audience why Congress hasn't been successful yet in developing a national framework? And there's no particular order, so whichever one of you like to speak first, please do so.
Can we just say Congress is Congress and leave it at that? That may be the simple answer and one of the more clear answers. But I'm happy to talk more detail about this particular issue. I do think some of it is just Congress being Congress. And I would say a second piece is that this is a pretty complicated issue with, I would say, conflicting motivations that don't cut cleanly across party lines. There's obviously a strong desire to lead in the AI space. There's also concerns about the technology and some of the companies in certain political views that are developing them. So I don't think Congress has shown a great deal of sophistication with some of these high-tech issues, not just AI, but there's also no national privacy framework and some of the other areas. And I think in part because there are conflicting views that don't line up with the traditional sort of party lines.
So I think this is one of the areas where there's a very clear bipartisan agreement that we need federalism on this issue because it is such a complex issue. We have so many competing definitions even of what AI is, that to try to cage all of the regulation of AI within Congress, within, let's say, for example, the FTC, are we going to, set the FTC to be in charge of our national policy? It's a very difficult challenge to do in one place. And I think, Republicans and Democrats can both agree that trying to do this all in one space is a major challenge. And as David said, the Congress members don't have a good grasp of what AI means and what they're trying to do with it. So it's best to leave it to the states.
Yeah. So I don't know. I don't know if it's that. I think there's a few things going on here. So one is, I think it's important not to lose sight of the fact that when Trump in his executive order talks about a national framework, no one would disagree with that as a practical matter. I think there's a lot of frustration coming down the pike if there's individual state laws, and if you're running, every AI model is going to be national by definition, and have to comply with different state laws that are similar but not the same. I think that'll be concerning. But you can't lose sight of the fact that that's not what Trump means in the executive order. What the Trump administration wants is they don't want regulation of AI. There's some carve-outs we'll talk about in there, but it's not like we don't want states to do this because we're busy building federal legislation. It's we don't want states to do this because we're not going to do it on the federal level either. I think they've been very clear about that they see regulation. I mean, generally, I think this is true of their view of regulation, but particularly here, regulation is stifling innovation, regulation as putting us behind, the rest of the world. The other thing that we can't lose sight of the fact is that the EU enacted the AI Act, after a couple of years, and they're starting to either slowly or maybe not so slowly backpedaling away from that. They're already concerned about how it's stifling innovation. They're already concerned that it's stale. They're already concerned that it's not really clear that it's really doing much or would do much of anything. So I think if you looked at the EU AI Act as a model for, federal kinds of legislation, you're already seeing that that's not necessarily dead on arrival, but it's a little bit on life support on arrival. So I think that's sort of percolating out there as well. And the final piece, and, we've alluded to this already, is that, well, no one's sure what do we mean by regulating AI? I think people don't want AI to harm people, but how you prevent that from happening isn't so clear. The Trump administration also has a very different view of harm than what some people might have. They're very against any sort of law that might try to prevent discrimination. They look at that as stifling speech. So there's a lot going on there, but even putting the administration's view aside, I think that people aren't quite sure what it is we want to stop from happening and what would be harmful and how you would define that. So I don't think we're going to see federal legislation. I don't know if I would say anytime in our lifetime, but I don't think anytime in the near future. I think it would have to be reactionary to something really bad that happened, and try to do it after the barn doors open a little bit.
Yeah, so one of the fascinating things for me, because I'm probably the only person among the four of us who has only stepped inside of a courtroom to observe what's going on in the courtroom. You guys have actually been in the courtroom and had business with the court, representing clients. So I'm really, really fascinated with the concept that a way to establish a national framework and perhaps to make it work is this establishment of an AI litigation task force. So could each of you explain to the audience what might be some of the implications of the executive order establishing an AI litigation task force and the task, presumably this task force is going to evaluate these state AI laws. So what are the implications? What might be the fallout? What should stakeholders be thinking about in trying to figure out what the president has in mind and how this might impact on various stakeholders?
I think one of the ironies here is that in what I think is an attempt to increase certainty, this is kind of will increase uncertainty for a while, because there are some questions about, the basis on which they would bring any sort of case or challenge, how effective that will be, on what grounds does sort of the federal government have the ability to challenge some of these laws. And it won't surprise anyone to hear that litigation takes a long time to work its way through. So I think part of it is an attempt to get their arms around what's out there and maybe more specifically identify what the administration views as problematic in various laws. But in terms of getting to a resolution as to whether those laws can be challenged, how they'd be challenged, that's going to take a long time. So obviously there are preemption issues and that sort of thing. And a litigation task force that leads to litigation in the courts is not going to come up with any quick answers, leaving sort of participants in the market a little bit in the dark for a while.
Austin, any
I'll,
thoughts?
I'll let Austin go. Jerome, I'm more like you. I've also been in the courtroom, but more to observe. So I'll leave it to these litigators to talk to that better than I can.
So, and my thought on this is that state AGs in particular have to be able to police fraud and misconduct within their boundaries. And sometimes that conduct, it crosses borders. We're talking a digital age here, but states have long been empowered to go after those who are doing wrong in our communities and harming our constituents. So states have a lot of power to regulate things that happen within their borders, even if it has cross-border impact. And so I wanted to sort of take issue with one of the things from this executive order and the national framework. Beyond trying to do this through executive order, bringing it to litigation, bringing it to cases, National Pork Producers v. Ross of 2023 was a decision that the Supreme Court reaffirmed the rights of states to regulate activity and products available within their borders. And it said that states have to be able to say, this is what you can do, this is what you can sell to our citizens, this is what you can do within our boundaries. And even if that has some extraterritorial effects, as long as it's not intentionally discriminatory, that is part of the state's necessary police power. So if I say within New York, we have an AI likeness law here, right? You can't use someone's likeness powered by AI to make them say things that they object to. If you have someone outside of the state who is making deepfake likenesses of other people, say in Ohio, I believe doesn't have a similar law, the New York resident can reach an Ohio user making a deepfake from New York law. On the other hand, if we said you can't use an AI that is based in Ohio, that would be cross-border discrimination. So, I don't want to go too into the weeds on this, but the idea is that the litigation is going to have to cross borders, and it's going to be state by state because we need to protect our citizens.
Stuart?
Yeah, no, I agree with what everyone has said.
And one thing I'd note, just following up on the sort of national pork producers discussion, that's the sort of a commerce clause approach that the litigation task force might take. They're also clearly trying to set up a broader preemption type attack on laws they don't find that they disagree with. And I guess the trick there is it can be difficult to establish preemption when there's no federal law or regulation. And that's part of the reason, I think, why the executive order directs the FCC and FTC to try and start issuing some regulations in this space. And that will then potentially lead to more litigation by the AI litigation task force, all of which, to my first point, takes time and kind of for now may increase uncertainty despite the desire to decrease uncertainty.
So let me seek some clarification from you, David. I was surprised, and perhaps because you and Austin are litigators, you guys were not. I was surprised that the executive order specifically called out Colorado. I mean, a specific state it called out as if to suggest that that's one that they have their eyes on, and perhaps there'd be some action. So, Austin and David, what's your take on why they specifically pointed to Colorado? And then my next question is for you, Stu. You've spent a lot of your career in protecting clients in the financial services space. There's preemption issues all over the place in the financial services space. And so David alluded to the Commerce Clause as a basis for taking those preemption actions. And from my law school days, the Supremacy Clause and the like. So first, Austin and David, why did they single out Colorado? And were they sending a message to Colorado or to the industry? And then Stu, what do you think about how preemption has played out in other contexts in the financial services space, and whether that is instructive in terms of how it might play out in this AI space?
I think they identified Colorado specifically for two reasons. One, it was one of the first to pass a comprehensive law, similar in type. It's not identical to the EU AI Act, but it's kind of similarly structured. And so that was one reason. And the second is that it included what the executive order considers sort of discriminatory. Well, in its provisions, purportedly trying to be anti-discriminatory, that I believe the executive order views that as being discriminatory or requiring untrue responses. And so it had the double whammy of being sort of first and most comprehensive, and also having a substantive provision that I believe the executive order intends to target and will be a focus of attention. It was I sit here in California. It was notable that it didn't specifically call out California, which the administration sometimes is wont to do. But, I think to the extent any state has similar provisions that the executive order is identifying, those will be subject to review.
I think, it's funny because California has by far the greatest number of regulations of AI, specifically picking out AI as a target of regulation, and I think followed by New York, in fact. but I feel like they picked Colorado in part for political reasons as well, that, Colorado's AI anti-discrimination law is not unique. New York and California also have employment-related anti-discrimination laws that target AI decision making. But I think that Colorado is in some ways considered more of a swing state than New York or California. It's blue, but it's a sort of conservative Western blue. And I think perhaps the thought was that they could put some pressure on Colorado in a way that New York and California would be more likely to resist.
So it's interesting. The political angle is interesting. I hadn't thought of that. I really do think it's, what Dave was saying, the algorithmic discrimination, which is the centerpiece of the Colorado Act, high risk systems that are making consequential decisions, and you shouldn't be able to discriminate. I mean, to me, that's like the low hanging fruit for the Trump administration. I think the problem they have with New York and California, and acts like that are twofold. One, the New York Raise Act didn't act at the time the executive order got issued, but even if it had, I think that, they don't love the tech industry, or they blow hot and cold on, large tech in the administration. So I don't know how much, laws that impose obligations, requirements on the tech industry bother them or not. I think it, depends on the day you catch them. But also, those are laws really dealing, even though, people will say they're burdensome and impose obligations, they're dealing with systems that cause harm to individuals. And you can imagine them being a little concerned about blowback of, why are you going after a law that is designed to prevent, death and personal injury and chemical weapons and nuclear weapons, things like that. Like, that's harder to have a good narrative over. It's easier, I think, on the Colorado Act, which is, algorithmic discrimination is just another way of having a woke AI law, and that's what that really is. And those are the kinds of laws that we want to go after and target. So I like Austin's political angle as well. It's how much three-dimensional chess are they playing? But I also think a lot of it is this, they see the word discrimination, and that's like that's table stakes for them.
The New York City Bar Association is a dynamic community of over 23,000 legal practitioners. Members shape the future of the legal profession, serve the public, and gain an edge in their careers. To learn more about becoming a member of the City Bar or to join today, visit nycbar.org/join. Save 20% on semi-annual dues when you join. Call Customer Relations at 212-382-6663 and use code POD24.
So let me just seek clarification, because perhaps I'm misreading the three of you, but it seems to be a consensus building among the three of you that Colorado, California, and New York may receive some attention from the litigation task force. We don't know whether they'll bring an action or not, but they may. In light of that, what would you guys be saying to stakeholders in those states, particularly because, as you know, one of the uncertainties that David has been worried about with litigation, not just because it takes a long period of time, but businesses typically plan over the course of a long period of time. They can't change their plans on a daily basis. So should a business think about, I'm looking at these requirements in California, Colorado, New York, and it's likely that the administration is going to challenge them. Should a business be thinking about that? Or what do you say to one of your clients who might say, Is President Trump going to go after the RAISE Act and the California, what I would say is the predecessor to the RAISE Act, because the RAISE Act essentially was designed, David, substantially like what California had done. That's what the governor of New York said in her press release. She linked them directly. So what should stakeholders be thinking about in light of that?
I think that it would be irresponsible if you're a company that's covered by one of these laws to sit back and hope that it's not going to apply to me because, first of all, most of these laws go into effect, a year plus from now. But to the extent to which, you have to start getting your paperwork together, start putting in policies and procedures to comply, I think it would almost be, corporate malpractice to not do that and roll the dice hoping that these are going to go away. I think that, obviously you monitor what's going on and things could change, but to the extent to which you feel it's going to take us, 9 of the next 12 months to get into compliance with the RAISE Act, I think you have to do it and assume it'll be in place. And if not, maybe you spend some money and some resources getting to that point. But I don't think you can hope that, well, we'll see where we are 11 months from now and scramble the last minute to comply if it turns out that, that shoe never dropped and the administration never brought in action.
And the other thing I'd add is an executive order is an executive order, which means it can be changed when there's a new administration. The state laws will likely remain on the books. And so I think there's a great deal of uncertainty, but to Stu's point, I think you have to proceed assuming that laws will stay on the books, at least until it becomes clear otherwise.
I mean, just to further David's point, an executive order is really, it's a presidential directive to the executive branch. And while it may have some effect outside of the executive branch, the idea constitutionally behind the executive order is that between separation of powers and federalism, the president is very limited in his power to executive order states to do or not do anything. It's, the executive order, absent an act from Congress that says, we're going to empower the FTC to deal with these AI issues, I think it's not the strongest form of law, right? You're going to have a state statute is going to most likely stand up to that. And at the same time, the state statutes I don't think there's anything terribly surprising in them. I think that for the most part, they regulate conduct that businesses could anticipate that would be regulated by other means anyway, and that compliance with those requirements is not going to be any more burdensome than the requirements to responsibly and ethically run your business. I don't think there's no shock here.
Yeah, but I would say even if, come April, the Justice Department were to start filing lawsuits, I think we'd still advise clients, don't bank on the fact that, these laws are going to go away, even with a lawsuit filed, and you need to come into compliance and take the steps to do that and, monitor what might happen.
Definitely.
Yeah, so I'll make a prediction that I was trying to get to when I asked Stu the question about financial services. So, Stu, I'm sure you and David as well, you followed this. The OCC has been pretty aggressive lately in preempting state laws. It came out with a notice of proposed rule making 2 of them very recent to preempt state laws. So while that is not technically litigation, I wonder whether or not, as a result of what the litigation task force is doing, the litigation task force won't communicate with the various agencies like the FCC, like the OCC, like the FDIC, the Federal Reserve, the CFPB, and the like. And so I wonder whether there'd be more action in that area. So I'm going to move on to another area. And actually, David, I want to start with you and then get Austin and Stuart's take as well. because you've spoke to this actually before, which is to say, President Trump, he has in the past used the Broadband Equity Act and Deployment Program to try to restrict funding to use funds to provide an incentive for states to do what he wanted to do. And so it's showing up again in this executive order. So what do you think he is trying to do by including the restriction on federal funding the states under the Broadband Equity Access and Deployment Program? Is it like what he's done in the past? Is it something different this time around?
So, Jerome, do you want me to give a couple minutes background as to what it is we're talking about?
Yeah, please.
So what Jerome's referencing is what's called the Broadband Equity Access and Deployment Act. Was an act passed by Congress and allocated about $42.5 billion to the states for high-speed internet access. And there's a formula for how much each state gets. And the idea is to expand out internet access to rural communities and people that might otherwise be in big cities and get that. What happened was most states were able to do or complete the physical infrastructure, build out the fiber and do all of that into underserved areas for some fraction, not necessarily a small fraction, but a fraction of what they were allocated. And so there's about $20 billion left in that fund that's been allocated. It's called what's referred as the non-deployment fund, that states now have allocated to them, but don't really need to build that physical infrastructure. States have taken the position of, look, that money was allocated to us. We can now, go build parks with them, but we sure should be able to build, or not build, but allocate that money to any sort of function that is related to broadband access, AI education. They've even argued, job training, but anything that's sort of digital literacy related, cybersecurity should be broadly construed as part of the non-deployment fund, and they should get to allocate that. Not everybody agrees, with that. And then, David will now talk about how in this executive order, Trump is using that as that money is sort of sitting there, but not yet spent, but states sort of see in their coffers already as a stick.
Yeah, and I think it's really a second way of attacking the laws that the Trump administration disagrees with through, instead of challenging them in court, the idea is to bring pressure to have them changed by the state legislature. And the federal government has had success causing changes in state laws through federal funding in the past. For example, a lot of freeway money was tied up with the raising of the legal drinking age to 21. Now, whether you can do it by executive order as opposed to congressionally passed law, and is a constitutional question that I think is not fully resolved and goes beyond this specific issue, and is one that I think has been debated pretty heavily in the past year across a whole bunch of different dimensions. There's also the question of whether there's enough money in the BEAD sort of bucket to actually make a practical difference. As Stu said, there's about $20 billion sitting there unallocated right now, or sort of unused. You spread that around, is it enough? Is California going to change its law because of $1 billion or $2 billion? That's a political question that I can't answer, but I think it's a question that's out there. And partly because of that, I believe the executive order also said that other sort of agencies and departments should look for other buckets of money that they could potentially withhold should these laws, whatever laws that the administration deems improper, stay on the books. So I think it's really just the executive order is trying to set up a 1-2 punch where they're going to challenge laws they disagree with in court and withhold funds to try and get those laws changed. Whether that's effective, I think, is a broader conversation that goes beyond just the AI regulation, and is a lever that administration is trying to pull across a whole bunch of different issues.
Yeah, and the loose connection they're trying to make here, I think personally, the loose connection is that high-speed broadband access is related to AI because you need that sort of access to use an AI tool. And so, if you are not playing ball with this national framework, then you don't deserve to get the money for this high-speed internet access because that's going to go to AI. And obviously, you're not part of the nation's mission on AI. That's sort of the theory of how they link those two, what would seem like wholly unrelated topics together in the executive order.
I think on top of the 10th Amendment, I think you brought up the drinking age, the South Dakota v. Dole from 1987 issue. I think on top of that, there's also an impoundment issue. I mean, Congress already appropriated this money, and typically the principle was once Congress appropriates the money, the president is supposed to spend it. And withholding it for reasons that aren't even in the statute that appropriated the money strikes me as another violation of the separation of powers, because Congress didn't appropriate this money to be used as a carrot or a stick. It was more for promoting broadband equity access and deployment, and to use that money already appropriated as a carrot or stick, it strikes me as raising an impoundment issue.
Yeah, so I'm going to shift to another area within the executive order. So the national framework specifically expresses an intent to preempt laws President Trump or the persons who will be essentially implementing the national framework would characterize as, quote, mandating deceptive conduct in AI models. And Stu, I think that was probably what they were concerned about in Colorado. You guys correct me if I'm wrong, but New York also has a local law, meaning New York City, in the context of employment, where if you're applying for a job, there are certain disclosures and other obligations. Are those the type of laws, i.e. Colorado and then the New York City law dealing with employment? Is that what they're concerned about when they say, quote, mandating deceptive conduct, because they are concerned about, and I'm not saying it's a legitimate concern, but they are concerned about potential for some form of discrimination that these laws are designed to prevent from occurring, but they see as these laws likely encouraging a sort of discrimination. Could you make sense, please, of what they mean by, quote, mandating deceptive conduct in AI models?
Yeah, Jerome, is exactly what you said. They're great marketers in the administration, great at twisting what otherwise people would consider to be like sort of the way you'd language something. But it's exactly right. Their argument would be that if you impose a law like in Colorado, where if it's a high risk model, you have to take steps to prevent algorithmic discrimination, they would argue, well, that's forcing you to program the model to be fair. And that by programming the model to be fair, by definition, you are engaging in deceptive conduct, reverse discrimination, the list goes on and on. But that's exactly what they're getting at, that anything that looks to, is helping to protect people, they would argue by definition, therefore is going to harm people.
I think that if you look at what a lot of algorithmic decision-making models have done and the areas that they find discrimination within them, you see what the root of these rules is that, for example, I'll just take the bail decision tree, right? Like, you take all of these statistical information and you find that more crime is reported in certain zip codes. And so if you assign to a zip code a risk factor for letting someone out on bail, that they are from a particular zip code, well, that's facially neutral, right? But if you look deeper at that, zip code was heavily minority due to redlining rules that may no longer be in place, but the neighborhood is established as it is. So you use a zip code as a proxy for a high crime area, suddenly you're more likely to incarcerate someone because they live in an area that was designated to them by redlining. And so you have discrimination hidden in the model. When you start examining that with a black box AI model, for example, you're going to have to go back and say, look, is this having a disparate impact on people of color? Is this having a disparate impact on women? You do the math and you break this down and you say, yeah, it looks like all circumstances being equal, the system is behaving more punitively toward minorities. And so you tweak the system, right? But then you're tweaking the system in a way that may make the system harsher toward non-minority populations, which a lot of people from non-minority populations have started to object to as what they're calling reverse discrimination. Rather than considering it an equalization, they're saying, now you're just being harsher because the algorithm says I should get better treatment, but you're making the algorithm harsher because, those people over there were getting harsh treatment as well, and now you're discriminating against me. That's the theory behind it. And maybe I can't say much more than that, but it's definitely, that's what their argument is. And it comes down to the social science of it and the mathematics of it.
Okay, so I have a couple more questions and then we can wrap up. I think Stu or David pointed out that it's unlikely that Congress is going to do something in the short term that's likely going to be a comprehensive framework. It's just too difficult. And when you think about competition, you can look to the EUA Act and say, well, they did something comprehensive and it hasn't turned out like they thought it would turn out. So doing something comprehensive coming out of Congress, I believe, is going to be a heavy lift. I also believe that the complexity of a lot of these issues will make sure that they end up in court. But because the courts themselves haven't had a lot of experience in dealing with a lot of these issues, there's going to be inconsistent court decisions as well. And I think, David, you were making the point that litigation takes a long, long period of time. So I'm of the view that when you start to get into all these preemptions potentially of state laws that conflict with the national framework and the litigation that might arise, I think it's going to be a really, really heavy lift. And then finally, David talked about the 1-2 punch, litigation and funding. I would assert that there's a third punch that could come along, but not likely, which is probably why David didn't include it. And that is some major legislative change that deals with this. So how do you guys think about it? Do you believe this is going to be a heavy lift for the national framework to do what the president has in mind? Or how do you guys think of it? What's your take on whether this is going to be something easy to do or not so easy to do?
I'll jump in. So I think it'll be a heavy lift. I don't think there is, I was saying this, at the beginning, I don't think there is support for the administration for a federal law. It's not like the executive order said, and here's the 6 things this national framework legislation needs to do. And I urge Congress to, spend 2026, working on this. Right. There's no guidance in the administration what that national framework might look like. So I don't think, as I said, there's, real support there. So once you start with that, I'm not sure how much Congress to do. But I think, again, the real challenge is, other than picking off specific areas like, child safety, which the executive order explicitly says, that's fine at a state level. Other than picking up low-hanging fruit like that, I think it's hard to create, like, what does an omnibus AI law look like? It's like so many things we talk about in the law, you'll know when you see it when there's a problem. But then is it too late to try to backfill legislation to try to stop it going forward? I think people really struggle with, even if Congress all agreed they really got to write something down and pass something, what is it that best protects the country, the American people, fosters innovation all at the same time? I think is a real legitimate challenge for folks.
And to Stu's point, it's not like there was a legislative framework before the order, right? And this is not a particularly new issue. It's been a few years. And for the last few years, there were one-off attempts at regulating specific issues, deep fakes, that type of thing in Congress. But it's not like there was a pending US AI Act, anything like the EU AI Act. And so I wouldn't expect to see one in the future either. And then the question becomes, if the administration's goal is really to have it loosely regulated, and that's what they want, it'll be a question of federalism as to how that works out with states that disagree. And that'll take time to play out.
I think that a lot of members of the public have legitimate concerns and fears about where this technology could go. And some of the things that it can do are concerning. We get lots of complaints about scams that use AI generated images and sound to make people think that their grandchild is calling them or that they've found a new romantic partner online. There are lots of things that scare people and they want a response. They don't want a low regulation free-for-all. They want the government to respond. And it seems like for the most part, it's the states at this point that are responding.
Final question to get your thoughts on. I could make a strong case that the administration learned from some of its earliest unsuccessful attempts in the AI space. For example, I think when you look at the executive order, and as Stu pointed out, it exempts child safety protection. It also exempts AI compute and data center infrastructure other than generally applicable permitting reforms and state government procurement and use of AI. I think the Trump administration looked across the landscape, and when it was thinking about either votes in Congress or it was thinking about areas that the states have the best chance of winning a preemption argument, they picked those three and they carved them out. What is your take on why the president carved out those three areas?
I think child protection always goes a long way. You can wrap up a lot of legislation in terms of, protect the children, and that's going to get some people to overcome their hurdles. Similarly, the data center infrastructure in a lot of towns, people have been promised good jobs and economic revival, only to find a noisy factory with no people in it. And sort of the not in my backyard regulations of where you can put those heavy industries. Those, again, are very popular rules. And then state government procurement and use of AI, I think, is just one of those areas where the state is acting as a market participant here rather than as a regulator. And the states can say internally, I don't want to purchase an AI that discriminates. I don't want to be relying on the AI to make decisions without human oversight. Those sorts of things are really internal market decisions made by the states as market participants.
Stu, David?
Yeah, in some ways, this is the low-hanging fruit, right? Everyone's going to agree with protecting the children. States, including Republican states, will want to control what is built in their backyard. These are kind of the easy calls that the administration doesn't want their folks to trip over. They're also not particularly large exemptions, right? I mean, this is protecting children is, as I said, low-hanging fruit. It's easy. Businesses aren't really trying to harm children, and there may be some difficulties in implementation, but that no one's going to object to that. I think the harder questions and the sort of more comprehensive ones are what they're looking at to target through the executive order.
Yeah, I totally agree with that.
Thanks, guys, for your time and for explaining these very complex issues. I will say that these particularly thorny issues that the president has chose to tackle through an executive order will probably play out over the course of time. So we probably should revisit this in 6 months or so. But this has been absolutely terrific in terms of providing guidance to market participants and stakeholders. And we look forward to your participation in the next podcast hosted by the task force. Have a wonderful day, everyone.
Thank you for listening to this episode of the New York City Bar Association podcast. Opinions expressed are those of the speakers and not necessarily of the City Bar. If you enjoy this podcast, please like and subscribe wherever you listen. Find more City Bar podcasts on Apple, Spotify, YouTube Music, iHeart, or at our website at www.nycbar.org/podcasts. Be sure to check out This Lawyer's Life, a professional development podcast where we talk with lawyers about seizing opportunities, learning lessons the hard way, and about what makes them tick. And don't miss Building Belonging, a podcast that embraces authentic conversations about DEIB solutions by amplifying the most marginalized voices in the legal industry and exploring spaces others dare not. This podcast was produced and edited by Jalen Martin.